Good morning, everybody. Everybody who's over Zoom this morning, if you all wouldn't mind muting your microphones until I call your case. I do have several people in the courtroom this morning. I just want to make sure that we can get everyone who's in person and is ready to get their cases completed so that they'll be done this morning. Everybody ready to proceed this morning?
Yes, Your Honor. At this time, I'm going to withdraw the two motions I have on the docket. Mr. Ratner and I have been able to.
Okay. You just
They're
make
different resolutions.
Okay. So the one, let me see, we had a motion to suppress that was set in Jose Murillo 20 CT 1074. Has that one been resolved?
Yes, Your Honor. That case would like to set for plea. As soon as we can, the state is offered me by no sanction.
And is Mr. Murillo in custody or is he out?
He's out of custody.
I didn't bring my calendars with me, so I'm not exactly sure when my plea date is. The 2/18 date will work. Yeah, just get in touch with Jen. I don't know how many pleas I have on there, but if I have more than a few, I'll usually stagger them.
I think we've been setting at 1:30, so probably great.
Hey Ruby, can you tell me how many pleas I have set on February 19th at 1:30?
I'm sorry, February.
Oh, February 18th. I'm sorry, it's the 18th.
Give me 1 second, Your Honor.
Thank you. I could probably do that myself too. I'm just always worried that once I get out of one screen, then I get into another, and I don't see any. Oh wait, it's the 18th. It's the.
Some of those are.
I'm only showing one plea so far, set at 1:30. So we'll just set this one also at 1:30 for a plea on February the 18th. Okay.
And then my other case was with Hudson. We don't have the case number.
Hudson is case number 20 MM 722.
Judge, when I filed this motion, there was a different prosecutor on board. Mr. Rabb and I both agree that my client needs to participate in a substance abuse evaluation before we can determine an appropriate course of action. She does have insurance and she lives in Fort Myers and is going to go to Salis here today.
Okay.
And to how to schedule that without much the substance abuse evaluation. So if we could continue this to the next pretrial date.
This was set for a motion this morning, I thought, on Hudson. Are you withdrawing the motion?
I am withdrawing the motion here.
Okay.
And I probably.
You were right, Joe, there were two.
And I will not be required.
Okay. So what we want to do is set this on a pretrial, right?
Correct.
So we'll set that. I have one, and I believe the next one is in April.
Actually, plenty of time, Judge, and when I get her evaluation back before then, I'll send it to Mr. Brown, and he can send it to her before then, we'll let you know.
Okay, sounds good. Let me just look at my calendar.
I'm sorry, Your Honor. This is for Michelle Hudson.
Yes, ma'am.
Okay, they're already currently set for a pretrial on the 11th
On the 11th of this month?
of this month, correct?
I think that that's going to be too soon in light of what I'm having counsel represent to me. So I think we should move this one to my April pretrial, which I don't remember what that date was.
April 22nd. Your Honor, it's April 22nd.
April 22nd?
Yes, at 9 a.m.
Hey there. My two pretrials are April the 22nd at 9 a.m. PD pro se, and then in private is what, the 23rd or the 21st? I did not grab my calendars because I didn't realize I was going to need them this morning, and here I am. I needed them immediately. Oh, thank you. Okay. Bye. Of course. I know. I kind of want to remove my robe. It's like boiling in here, isn't it? No, you guys are allowed to. I'm not. But I do have a fan. I might bring it back with me when I take a break. You are right. It is hot in here. Okay. All right. So you had those two, and then that's all. Okay. Let me just get back into my dashboard.
And Your Honor, I couldn't hear counsel. Are we not hearing the motion to suppress?
She's withdrawing the motion to suppress. Yes. Yep. All right. I do see another one for you. Well, actually, I see well, he's going in at 11, Mr. Prado. So you've got Justin Curry, 20 MM 253. It looks like you filed a motion to dismiss in that case.
I've withdrawn my motion to dismiss, Judge, and in its place, I've spoken with Mr. Rapp. I realize he doesn't have an objection, but we're asking the court for permission to depose the alleged victim and Officer Moore in this matter, given the statute on the charge and the jury instruction on it, as well as based on the probable cause affidavit. There's just some particular ambiguities. I'm not trying to go on a fishing expedition. I can tailor the deposition, or even, I would prefer it to be a deposition, but I can tailor my question specifically to what the victim saw, her point of view, where she was at, those type of instances. And I'm happy to work on an order with Mr. Rabb so that the parameters are clearly defined.
Mr. Rabb, I noticed that the motion to take depositions was recently filed. Are you prepared to argue it?
Yes, Your Honor.
I'm a little concerned that this case is a year old.
Yes, Your Honor. And as Mr. Bridges stated, the state does have an objection to the deposition procedure, which states that in any trial, circumstances, in this case, the witness and the officer both submitted a probable cause affidavit or a statement. The court does grant the deposition.
Okay, let me just take a look at this. Ms. Armpriest, are you looking to depose the officer, the witness, or both?
If I had to choose, Your Honor, it would be the victim. The only reason I want to also depose Mr. Moore is when he came into contact with my client, it wasn't exactly on scene. It was a little bit of time later at a different location, still very close. So there was a couple things I wanted to clear up with him. That probably I could discuss with the officer in the presence of Mr. Rabb just to get those questions answered. So we don't have to bring an officer in for a deposition, but I would still request to depose the victim.
All right, so what the court is going to do is I'm going to grant a limited victim deposition, and perhaps you and Mr. Rabb can work out the parameters of it. I'm concerned, I obviously don't want it to be an extensive one in light of the charges with this particular case, and denied on the officer. I think a conversation with the officer might clear some stuff up. So
I'll submit an order to Mr. Rapp, and he can make any changes once we agree upon it. Hopefully, I know he's very busy today, but by tomorrow we'll send a copy to Ms. McAllister.
okay, sounds good.
And then as soon as I can get that scheduled, because it's not lost on the defense that this case is rather old, we'll get it going as soon as we can.
Sounds good. All right, thank you.
Thank you, Judge. May I be excused?
You may.
I'll see you 24.
Thank you. Mr. Gorman.
Judge, I think I got to the crown.
You can.
Sorry.
All right. Are you ladies here observing? Let's make sure that you're not lawyers, and I haven't met you guys before.
Yes, Your Honor.
Oh, nice to meet you both. Welcome to my courtroom. Thank you. Thanks for coming in today. All right, let's see. I got a bunch of people over Zoom. Anybody have anything that's quick, easy, that we can talk about? It'll only take a few minutes. Stephen Ramuni. Mr. Ramuni, I see you waving. Sir, what can I do for you this morning?
Good morning, Your Honor. I represent Mr. Leo, who's also present on Zoom. And Mr. Leo, can you unmute?
Let me see. Where's Mr. Leo? There he is. I see you, sir. And this is case number 20 MM 2423. It's a motion to seal. And let me just ask the state, is there any objection to the motion that's been filed, sir? And the state has indicated that there's no objection, so it will be granted.
Thank you, Your Honor. I've already submitted an order through your judicial assistant.
Oh, okay, I've got a stack. Yes, ma'am.
For the record, we do not have the $42 that needs to be paid. So we can go ahead and get that in prior to processing the
The
order.
$43 are submitted before I can grant this motion.
That'd be fine, Mr. Leo. If you can go down and pay at the clerk's office $43, that'll conclude your case.
Okay, so what I'm gonna do is, let's see here. I'm just gonna like a note in here that upon the cost being paid, that it'll be granted, but I'll do that so that I don't take up a lot of time. I'll do it as soon as I'm done with these hearings.
Thank you, Your Honor. May we be excused?
You may be excused. Thank you.
Have a good day.
Thank you, Your Honor.
You too.
All right,
Thank
this
you,
is Steve
sir.
Ragosa. I wanted to be pretty quick.
All right, let me just pull your case up, Mr. Bragoza. And that would be State versus Alexi Caballea,
That's correct.
20 CT 1456, request to
Judge,
subpoena medical records.
Yeah, Judge, I've listed witnesses on this, and I have not had a chance to get them subpoenaed for the hearing. Also, is this hearing going to be by Zoom, or is it going to be in person? Because I don't think this hearing can be done by Zoom, because I have the witnesses supposed to have a lot of documents that go back and forth with the officer and his deposition.
Yes. Okay, hold on, Mr. Ragoza. Mr. Rabb?
Your Honor, the purpose of this motion is a request to subpoena medical records as the state is entitled to pursuant to the statute. The only standard that the state has to show is relevance. I ask the court to take judicial notice of the full record to review the cause affidavit as related to it. On the day of the incident, the defendant was involved in a car crash. The defendant was suspected of being DUI. He was transported to Physicians Regional Medical Hospital by Collier EMS. There was a blood drawn done by medical staff for the purposes of providing medical treatment. And the state has provided notice to Mr. Ragoza as a representative of the individual whose records are being requested from. The state has met its verdict. Mr. Ragoza is attempting to meddle in waters as it relates to this issue and a consensual legal blood draw that has nothing to do with the medical records.
Mr. Ragoza, the state has pointed out that there are two issues here. Number one, a consensual blood draw is not part of the state's request for the medical records. And number two, he says the only standard that the court has to apply to this motion would be whether the records are relevant to the charge that's before the court, which is driving under the influence. And in fact, that this has been noticed for some time and doesn't understand why this matter can't be heard today. And the court has truly the same concerns.
Well, this is what the issue that I've been trying to explain to the state when we did depositions. The case law in this case is, Judge, he was brought to the hospital. The officer basically tricked him to give information that he was DUI, and they tricked him to getting consensual blood draw, and to the nurse giving him the officer information about his blood BAC. After that, the state went back in and trying to use a subpoena to get those same documents. And I think that the first document should not be admitted because of the trickery. He doesn't speak English, and the officer gave him documents in English saying, sign this, which he did. And my argument is that they should not be able to get any of those documents because they first obtained them by trickery, and they can't go back in with a subpoena from the court and say, well, we tricked them the first time. Now we want to get them the correct way.
So, Mr. Ragoza, wouldn't the issue of trickery, if in fact we have to have a hearing on that, wouldn't that be the subject of a motion to suppress or to exclude the records based on some unlawful behavior of the police? The issue for today is whether the records can be obtained by the state, which under the state's argument of relevance, they could be obtained. And then the proper course, at least as far as I'm looking at this, would be if you feel that those records or that the information contained in those records were unlawfully gained by law enforcement, that it would be the subject of a proper motion to suppress, motion in limine.
Well, I was just trying to shortcut it, Judge. I agree. We can still do. I do have a motion to suppress pending and filed.
Okay, Mr. Rabb. So he says he agrees, maybe procedurally with the court.
Well, what I'm saying though, Judge, is that if you want to have two hearings on this, we can have two hearings. But the problem is
that I can only hear one of you guys at a time. Let me start with Mr. Rabb. You understand Mr. Ragoza, but you disagree with him. Is that correct?
It's not just the state, Your Honor, the court's history. Any case law that the court has found relating to medical records and a potential issue regarding obtaining of medical records relates specifically to law enforcement attempting to obtain medical records. What Mr. Ragoza is arguing is that there was, according to Mr. Ragoza, some impropriety as it relates to a consensual blood draw.
Right.
Regarding legal blood that has absolutely nothing to do with medical records as they relate for medical treatment that were taken by hospital staff at the request of hospital staff to treat the defendant. If a motion to suppress is brought, it would not be for these medical records. It would be for a different issue. And Mr. Ragoza is able to bring that motion.
Right.
It has absolutely nothing to do with this piece of evidence. It is a separate piece of evidence that he has issued with.
And Mr. Ragoza has indicated that he is going to file such a motion. And I do think that the medical records would be relevant. But I also do think, Mr. Ragoza, that you would have the ability to file appropriate motion with the court to limit or exclude portions of those medical records based on your argument about how they were unlawfully obtained. I just think it's putting the cart before the horse to deny the state the right to get the medical records first. So I'm going to grant the motion for the medical records subject to any exclusionary rulings that may be made in the future, Mr. Gregoza. So if you want to file that motion to suppress and set it for a hearing, I am scheduling in-person hearings right now for motions to suppress. Of course, we have to set them kind of specially so we make sure we don't have lots and lots of people here, but I do have the ability right now to schedule in-person motions to suppress and bring in witnesses. Also, too, however, I would encourage witnesses, if possible, to appear over Zoom because that limits the number of people we're bringing into the courthouse. I understand that some people don't have the ability to participate by Zoom and a lot of people don't like it, but the more people that we can have testify over Zoom, the better, at least for me, as far as following what I'm supposed to follow as far as CDC recommendations. So, yes. Right. They can file a motion to suppress us, whatever they want to think that should be suppressed, and give me some legal authority, and I may or may not agree with them, but I'm not going to limit counsel's ability to file a motion based on what they believe is something that was done improperly. And then, you always got that fruit of the poisonous tree argument at some point too. So I'm trying to go back into the recesses of law school, which is a long time ago for me, to the suppression issues that defense attorneys may craft. So Mr. Gregoza is certainly welcome to challenge whatever information is contained in those medical records, and I'll entertain the argument. And I'm sure, Mr. Rabb, that you'll have argument to the contrary on those things that you don't agree with. But we can certainly accommodate that motion at some point once it's been filed, Mr. Gregoza, okay?
All right, Judge,
All
if
right.
the clerk could just, when signs the order, just put over defense objection, please.
Absolutely.
All right, thank you very much.
All right, thank you, Mr. Gregoza.
Judge, did Mr. Gregoza say that was going to be a short hearing?
I don't, that's as short as I can
I
get.
was
Mark.
about to say, Mr. Casassa, whenever you tell me you have something that's going to be brief, I have to decide what that definition of the word brief means. Does it mean
Doctors are
short? Or
brief.
does it mean short in the terms of Mr. Casassa? Thanks, Mr. Gregoza. All right, Mr. Miller, you got a hand up, and then I'll take you, Mr. I can't read your name, Brusky. Mr. Miller.
I do, Your Honor. Thank you, Judge. I'm not so sure how short it is, but I have a calendar call with Judge Foster as well.
Okay.
I'm
Vincent Santanillo, 21MM21, motion to subpoena records.
Judge, that is the state's motion. There's also my motion, which is a motion to lift the no contact order and the no trespass order. And I believe Mr. Santanillo and Ms. Doyle are both present by Zoom.
Okay, is Ms. Doyle the alleged victim in this case?
Yes, Your Honor.
All right, well, why don't we start with the motion to subpoena records first? Mr. Miller, are you objecting to the motion?
Judge, Mrs. Doyle objected to the records. I did not represent Ms. Doyle. She's the listed victim in the case, but she has filed an objection, and that's, I believe, why the court or the state has set it for today.
Okay, first of all, I want to get Mr. Doyle and Ms. Doyle and Mr. Santinelli sworn in. I don't see Mr. Santinello. Oh, there he is. I need to have you both raise your right hand and be sworn, Mr. Santinello and Ms. Doyle. Do you both swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. All right, we are going to start with, let's start with you, Ms. Doyle. The state has requested some records and you are objecting to those records. Can you tell the court on what basis it is that you're objecting to the records, ma'am?
Yes, I mean, that whole evening, it was New Year's Eve, it was a big misunderstanding from what was allegedly reported. The police officers who were at the house told me that they would forcefully make me take an ambulance if I didn't get into the ambulance. I feel like I was being treated like a criminal that night. When I got to the hospital, I wound up leaving on my own. And so there was nothing wrong with me to prevent me from leaving on my own. And I just feel like I've been treated like a criminal this whole case. And I don't feel like my medical records should be brought up. They're personal, and I feel like I've already been through enough.
Okay. Well, I don't know if you heard the previous motion, but the state's, the motion before the court has to find that they would actually be relevant. And I looked at the information in your file. I can't find that they're irrelevant. I sympathize with you because I know that people don't want to disclose their medical records, but in a criminal case, the issue of medical records and that is before the court on a request to subpoena them is whether they would be relevant. And based on the information in the state's motion suggesting that there were certain things that were that occurred that night, the court does find that they would be relevant. Now, as I said, in the previous case before you, those are always subject to limitations that the court can impose regarding the use of the medical records. So there are two issues. Number one is, can you get the medical records? And number two is, can you use the medical records? So just because I'm saying that the state is able to obtain the records and look at them does not necessarily mean that if this case were to go to a trial, that I would say that the state could use the medical records. Does that make sense, Ms. Doyle?
Yeah.
Okay. So, yes, sir.
And Your Honor, just for the record, the state would also like to point out, pursuant to statute, that Ms. Doyle was also properly noticed that this was not a very level. She is fully agreeing with the objection, just to make sure that the state has met its statute.
The court will note that, but the court is granting the request for the medical records at this time. Okay, so let's go on to this. Yes, Mr. Miller.
I know I don't represent Ms. Doyle, but I'm assuming that the state's order is going to reflect that very narrow time frame, date and time for medical records that they're gathering.
Yes, just the day in question.
Yes.
Yes, sir.
Thank you, Judge.
Okay, thank you. And now let's go on to your request to lift the no contact order, Mr. Miller.
I believe Ms. Doyle is still under oath. May I question her, Judge?
You may inquire. Mr. Robb, can you hear Mr. Miller? I know that I've got it all the volume all the way up on my computer and it's not the best. Okay, can you hear Mr. Robb, Mr. Miller?
Barely, Judge.
Do you want to come up a little closer and I'll just move the computer over? I don't mind. All right, Mr. Miller, you can proceed.
Thank you. Ms. Doyle, please state your name.
Diana Doyle?
And Ms. Doyle, are you the listed victim, to the best of your knowledge, in a case of State of Florida versus Vincent Santaniello, case number 21MM21?
Yes.
And ma'am, did you contact my office asking me to file a motion to lift the no contact order and the no trespass order that was issued against Mr. Santaniello?
Yes.
And do you have any fear of your safety?
No, not at all.
All right. Do you want to have contact, personal contact with Mr. Santaniello?
Yes, absolutely.
And would you like him to come back to the residence that y'all share in common?
Yes, absolutely.
All right. Are you aware that if in the future you feel threatened or have any concern about your safety, that you can go to the clerk of court's office and file a petition for a restraining order?
Yes.
All right. Judge, I have no further questions.
You're up?
Your Honor, I have no questions, just argument.
Okay. Let's start. Mr. Miller, what is your argument for lifting the no contact order? It's your motion.
Your Honor, the alleged victim has just testified she's not in fear of her safety, that she wants to have contact with Mr. Santaniello, that she wants to have him reside back in the marital home. There's no allegation or no evidence of any prior incidents between these two individuals. She was not coerced or forced to come into my office and sign the affidavit. The affidavit was actually attached to the motion itself. And also contained in that affidavit is where Ms. Doyle is requesting the state to actually drop all the charges. So I believe we still have the freedom of association. I understand the state may have some concerns, but the evidence before the court is that Ms. Doyle wants to have contact with Mr. Santaniello.
Mr. Hebb?
Yes, Your Honor.
Thank you.
The state has proceeded to file charges on this matter. The state has also made contact with an independent witness as it relates to this matter and is proceeding forward with those charges. Despite the victim's wish to drop the charges, as the court is aware, it's the state's prerogative whether to proceed on criminal charges, and we have decided to do that after conversations and after reviewing all the evidence. The state would object to lifting the no contact order as a result of that, since there is pending litigation on this matter. We will stand by our objection and proceed to trial, Your Honor.
Mr. Miller, you said that they're married. I didn't see anything like about that in there. Was that just was that wrong?
That was wrong, Judge.
Okay. You said go back to the marital residence, so I hadn't heard that from the testimony.
I'm sorry, Judge. Not a marital residence, but it is a residence that they have shared in common for a period of time.
You know, I'll tell you guys, these are some of the most difficult for the court because the court sympathizes with individuals who want to reconcile their relationship, but also is concerned for the safety of a victim in what appears to have been a significant event. Although the court also does realize that there are some times where there are isolated incidents, and that doesn't mean that there's going to be a pattern of violence in the future. So it puts me in a very difficult predicament because I have to believe that in lifting a no contact order, that the victim is going to be able to reside in the residence safely and without further incident. And there are situations like this one where the court just does not know. And that's troubling to me, but at the same time, I don't see a criminal history with this defendant. So I am going to lift the no contact order in the hopes that this is just an isolated incident. If it did occur the way that I'm reading it in the booking sheet. I will tell you, sir, I'm doing this despite my concerns that this may not be an isolated incident, and that if I do find that there's any other disagreements between you two while this case is pending, it will be my ruling that you be taken back into jail and be held until your trial. So it's a good incentive for you to avoid conflict with your girlfriend, and that if you guys decide that you're going to engage in some type of an argument that looks like it's escalating, one of you leaves. And I would suggest that you guys maybe get some counseling together to try to figure out how to avoid situations such as this, because another situation even close to this happens, and I'm not going to be inclined to change my rulings in the future on this. Okay, so I am granting it, Mr. Miller, with some hesitation.
Thank you, Your Honor. I don't know if the court has already received an order. If not, I will email one to your office.
Let's see. Let's see here. It doesn't appear. I did get the order from the state. No. I got the order for the medical records, and
that's okay, Judge. I can have my I was about to say my Janet, but Janet, my paralegal, email one to your office now.
Is her name Janet?
She is.
Okay. Sounds good to me. And have you seen the order granting the state's leave to subpoena the medical records in this case, Mr. Miller?
I'm sorry, Judge?
Have you seen the order on the motion to subpoena the medical records? Because I have that. I was going to sign it in case you had any. Unless you
I have not seen it, Judge, because I am not counsel for Ms. Doyle.
Okay. Well, it says here, the state attorney may issue a subpoena for the emergency medical services and physicians regional hospital records of Diana Doyle regarding her treatment beginning on December 31st, 2020 or January 1st, 2021. And do we know when she was released from the hospital? Because it says beginning and it doesn't have an end date. Were you released the first, Miss Doyle?
They checked me in and then I left right away. So I was only there for probably about an hour.
Okay,
not even.
But it was after midnight?
Yes, it was after midnight. So it was the first. So my medical records would be from the first.
Okay, so I'm just going to put in here and ending on 1/1/21. That way, if you'd had anything else that happened with you medically since January the 1st, that this wouldn't be an open-ended subpoena. So, all right.
Thank you, Your Honor.
Oh, you know what? I need to get that to the clerk of courts. Never mind. I keep forgetting that I don't have a clerk. Not in court. Yes, sir. Mr. Miller.
Thank you, Judge.
Okay, we're good. Everybody
Thank you,
is excused on this hearing? Yes, you may.
Thank you, Your Honor.
All right,
you.
thank you, sir. Good luck to you both. All right, Mr. Levy, it looks like you only have one motion. You have a motion to expunge in 13 MM 815.
That's correct, Your Honor. Good morning. William Levy on behalf of Tulsi Gilly. This is 13 MM 815. Judge, this is the defense motion to expunge. The clerk has received the fee, I believe. We paid it. Just requesting that the court grant our motion. Just for background information, Your Honor, my client was granted diversion, successfully completed back in 2013. Stayed out of trouble, no prior history.
Any objection, Mr. Rabb? Okay, it will be granted, Mr. Levy. Just need an order. I don't see one.
Thank you, Judge. We'll send one over.
Okay, sounds good. Thank you.
Thank you. Have a nice day.
You too. All right. Mr. Casasso, you ready? Or I'm sorry, Mr. Brodsky, I did say I would call you and I haven't. Sorry about that.
That's okay.
And you're here for Christian Jorgensen, is that right?
Yes, Your Honor. I'm not a familiar face. I'm down in Palm Beach.
That's okay, no problem. I got you. It's 1997. This is an old one. MM 826, and this is also a request to seal.
That's correct, Your Honor. The filing fee's been paid. Everything should be in order.
And Mr. Rabb, any objection on this one?
No objection, Your Honor.
Okay, so it'll be granted. Mr. Brodsky, I just need an order from you.
You, I can email that to, I guess, it's Ms. McAllister?
Yes, sir.
Okay.
That's my judicial assistant.
Right. I'll send one over.
Perfect. Thank you.
Thank you. You guys have a good one.
You too. All right, Mr. Casasso, you're up.
Morning, Judge.
Good morning.
Judge, I have a motion to set aside an impound.
What's that?
I have a motion to set aside a vehicle impound.
Okay. And this is Roseanne Lockhart, 20 CT 461. Let me just pull it up.
Sir, there is an affidavit attached. Mr. Rabb had some objections, but I didn't think that they were something of merit, so
Sure.
he may want to address his objections.
Did you hear Mr. Casasso? He said you have objections that are without merit. So he's throwing punches already and it's not even 10 o'clock in the morning.
I would expect it no other way. Mr. Casasso, probation has informed me that through a David search, it does appear that the defendant still owns a vehicle. It's a 2017 red Ford, 2-door.
Are you saying besides the vehicle that we've listed?
It is showing as a currently owned vehicle on David.
Okay. Well, she has a vehicle. Judge, the argument was there are two people residing in this household, Miss Lockhart and her husband. There are two vehicles at that household, one occupied or used by Miss Lockhart for work as well as medical appointments. Mr. Lockhart also works and has numerous medical health problems. So the argument we have is there are two vehicles. There are purposes for both those vehicles. They both need to get to work. They both need to get to medical appointments. And I would think that that would fit within one of the exceptions to the statute.
All right, let's just pull up that statute because I haven't looked at it in a while.
It's good reading, Judge.
It's a good reason to refresh the court's recollection on the impoundment statute.
And Your Honor, as Mr. Casasso pointed out, the state's objection was that the residence that both the defendant and her husband live at, there is another vehicle registered to Mr. Lockhart. And that is the state's.
So that there's two cars or there's actually three cars?
There are this car that belongs to the defendant.
Uh-huh.
My understanding is that there's also an additional vehicle that belongs to her husband,
Uh-huh.
that is in her husband's name.
Okay.
So she is not precluded from being mobile since her husband does have a vehicle. And this is again for the defendant.
Judge, if I heard right, he's saying there are two people and two cars and therefore she should not be allowed to exclude the impound. And I would disagree with that under the circumstances.
It's sending me an authentication request to my cell phone, which I don't have with me in court. For Westlaw. No, I trust that you're, are you kidding me right now? I trust that your research is accurate. And I think Mr. Casasso is saying the same thing. I think he's saying that there's two cars in the two households, but both of them need to have transportation in order to go to work and medical appointments, et cetera, et cetera. And my question is would that be a proper exclusion under the statute if the court made that finding? And as soon as I pop up Westlaw, it tells me it's making me verify it on my cell phone. So
Judge, I did cite.
Who's got the statute?
I cite.
Oh, you know what? I've got a statute book right here. What's the statute number? I'll pull it up myself in a book, in an actual book.
316.1936G is the exception I've used.
What is it?
316.193, parent 6, parent G, small g.
161936G. Hopefully they haven't amended statute since 2019 because that's what we've got in the courtroom. I swear. Things are working against me today. All right. 316-193. Oh, there it is. 316.193 this is a really long statute, isn't it?
It is.
Subsection 6, and you're saying it's under G, Mr. Casassa?
G is the exception that I have cited in my motion, Judge.
How do I find that there is no other public means of transportation, Mr. Casassa? I mean, it says there's no other private means of transportation. I think I need to have a little more information, such as when they both work, and that there are no other means available to them. I don't know that I can make a finding of that just based on the representations from you today, sir.
Judge, I'll withdraw the motion and amend it and put some more detail in there.
I think we need to have more detail, and I think probably, I don't know where they live or anything like that, that there's no availability for them to get to the places they need to get, other than the vehicles that they have.
Judge, we could take judicial notice and Mr. Rabb's going to object to everything I do.
You may, and that's okay. That's
All right,
that's
Judge.
what lawyers do. They object, right?
So I'll withdraw the motion at this point and I'll refile it.
Would it be surprising to you to have a state attorney that didn't object to anything, which would be contrary to a state attorney that objects to everything, Mr.
Judge, I'm
Casassa?
just trying to get along with these guys. You know what?
I get it.
I'll
You
take
believe
care of
he's
it.
trying to
Judge.
get along with you today, Mr. Rabb.
We definitely did.
Well, there you go. See, so we guys have a consensus on something today. So yeah, let's get some more information on that motion, Mr. Casassa, and we can go from there. All
I'll
right?
do it, Judge. Thank you.
All right, sounds good. Thank you. All right. Yes, ma'am. Yes. Thanks for joining us today. All right, then we've lost Mr. Gorman again. And let's see, we've got Mr. Hollander, or is it Ms. Hollander? There's two Hollanders. Lee Hollander. What's going on with him today? I see that there was a motion filed and I don't see Mr. Hollander in the room.
Yes, Your Honor, the state requesting this will be such an issue. I believe that the state discovered Mr. Hollander has corrected that will be by appropriately the judge would hear tomorrow.
Okay, sure. We probably need to put it at the end of pre-trials because I think I have like 100 of them tomorrow.
That is what I advise.
Okay, we could do it, maybe like 11 o'clock or something. Or we could just ask Mr. Hollander to be on standby and we can, just let him know when we're done and then we can handle it then. So Ruby, can we add Mr. Hollander's case, which is Hector Chagoya, 20 CT 1563 to the end of pre-trials tomorrow, and then we'll figure out how we can get that addressed.
Okay, Your Honor.
Sounds good. Sir, your name is Mr. Caballera, is that right? Are you here today for a hearing, sir? Did we already call your matter? I thought we did. Oh, yes. Sir, you were here, Mr. Groza was joined us this morning. You wanted to still stay and you can still, stay over Zoom if you want to, but your hearing has been concluded. Can you hear me?
I'm sorry, not speak English.
Ah. Oh, no. My Spanish is terrible. Well, let's try the English to Spanish translator, which I do every once in a while. It's really bad, and I'm going to apologize in advance, but we don't have anyone.
Could be any worse than the water.
All right. Un momento. Por favor, hable con su abogado. Su casa ha sido escuchado esta mañana.
Okay.
Bueno?
Okay.
All right. Gracias.
Gracias. Bye.
Bye. I'm not sure, even sure that's right. Was it?
Yeah.
Do you know what it said?
Yeah.
It was right, Your Honor.
What did I say? I did, you're right. I said, would you please bring me a pizza?
It is pizza day.
It is.
It's National Pizza Day.
Is it really?
Yeah.
Then-
Today.
Really?
Today is National Pizza
You're
Day.
totally lying to me right now.
No, I wouldn't lie to you.
I'm looking it up.
I would never lie to you.
I can't get on Westlaw.
Today is National Pizza Day.
She had her goal that you need.
Oh, you're right. It is National Pizza Day. Really? Gosh darn it.
I would never lie to you.
I know you wouldn't lie. You might say it's National Pizza Day like every day of the week in the hopes that we'll order pizza for lunch. Right?
Right, yeah.
Joe, where are you treating us?
Oh my goodness. All right, Mr. Gorman, you're back. We're ready for you. Other judges trying to get you to come into their courtrooms?
Judge, did you need me to go down there for the remainder of the docket?
Hold on a second. Ruby's got a question. What's that, Ruby?
Did you need me to go into the courtroom for the rest of the docket?
No, there's just the only thing, well, we are going to have a plea at 11, but the other, these are just 3 motions, so we won't need you until 11 when we have 1 plea that's coming in this morning at 11.
Okay, thank you.
Cool? Thanks, Ruby. All right, Mr. Gorman, we're ready for you. Who do you want to start with?
Yes, Judge, first case we have is Brandon Walter, 874. This is a motion to expunge. Mr. Walter's case was no file long ago, and he's eligible. We filed the original certificate, and he is tendered to the clerk to check for $42 at this time.
Any objection, Mr. Robb? Okay, that'll be granted.
I'm sorry, Your Honor, I could not hear what case is that was granted.
Oh, and I just got out of the case, of course. It is State versus Brandon Walters, 20 MM 874. Request to expunge is granted.
Thank you.
Shu-Hong Wang, 19 MM 1413. This is defense's motion to seal, similar situation. Case has been dismissed. Excuse me. In this case, there was a withhold adjudication, and the defendant is otherwise eligible. Check's been paid for $42 at this time. We need to seal.
And Ruby, if you didn't hear that, this is on Shu-Hong Wang, 19 MM 1413. Any objection to the request, Mr. Robb?
No.
All right, will be granted. Thank you. All right.
Next, Judge, we have 10 o'clock bracket. This is Jacob Olszynski. Sorry.
Well, I don't know. I'll let you pronounce the name. 21 MM 13.
Yes, Judge. Mr. Olszynski's case was dismissed as part of the arrest. Firearms were taken by the sheriff's office. They are listed as an exhibit which has been attached, but basically it's several firearms. Even though the case is dismissed, sheriff's office requires us to get an order from the court, so at this time we're moving to return the property as they have no evidentiary value.
Any objection, Mr. Robb?
No objection, Your Honor. The state confirms that the case was dismissed.
Okay, then that motion will also be granted. Thank you.
Thank you, Judge.
I think that's everything this morning. How's your little guy doing? Is he doing all right?
Yeah, he's better. That's good.
That's good. Better is good. Never any fun to be a parent with a kid in the hospital, though. No. Well, I'm glad to hear he's better. Have a good day. You too. All right, so we're going to be in recess until 11. That's when we'll have our in-person play, right? I told him to come in, I think, at 11, Mr. Robb. I wasn't sure how long, especially with the motions to suppress, what this docket would take. Was he supposed to be here at 11 on that, on the motion that we just heard?
Yes, ma'am.
Oh,
And again, I think that
on that motion?
as you pointed out, Your Honor, our standard is about as low as.
You guys did great. It's just, hey, you know what? Better to ask for more time than less, because if you find out that you need more time and you don't ask for it, sometimes we're stuck, so.
I have read more case law on medical legal, and I have.
Well, I saw that there was a great big stack of something this morning, and I was going to start plowing through it And then Jen told me, you don't need that case law. She took it away and said, everything's been resolved. Yeah, it looked like about like that.
This was for you, Ken. That was different.
Oh, that's more cases?
This is the medical record.
I love reading cases.
I can
We're in
certainly share
recess.
that with
you. There we go. All right. Anybody back on
I think the new attorney is learning better when sitting at the table as opposed to the jury box. So I request that they sit at the table.
Oh, great. Let me just move this so that I don't know. I never really sat in the jury box when I was an attorney, but I was a divorce attorney, so I felt like I should really be sitting next to
I think
them.
you're more in the game when you're at the table as opposed to the box. It's like the bullpen.
Oh, okay. I don't know the difference. I've never been in the bullpen. I was never invited.
Like a relief pitcher.
Yeah. Yeah, well, I wasn't
just sitting back
I wasn't
there.
very good at that either, so.
Like a starter, you're not coming out of the bullpen.
Yeah, see, you're in the dugout, it's the rest of it.
I wasn't good at softball either. That's unfortunately. I tried all of them, but it was not a good idea. It was not. What?
I'm sure you have your own.
I'm not so sure about that. So we got to figure out where Ms. Armpriester is. Is she? I don't see her over Zoom, so maybe I think she's probably going to be in person.
I can text her.
Okay. I mean, it's only a couple minutes after 11, so it's not a big deal, but I wasn't sure. Did we give Mr. Prado the plea forms and stuff? Does he have them yet? We have a form we need to have you review, sir, before we can take your plea this morning. When she left, I think she said, I'll see you this afternoon.
That's what she said.
So she may not have realized that we had scheduled this at 11. I forgot to say to her, oh, wait, we have the plea at 11.
I just texted her, Your Honor.
Okay.
And I just shot her.
Okay. So if we can't locate her, maybe we could locate somebody in the public defender's office that'd be willing to step in and just take the plea for this gentleman since he came in. Find us an attorney, any attorney.
Do I have permission to use myself?
Of course, sir. Yes. Anything you can do to try and figure out what's happening will be appreciated.
Hi, how are you? This is Lawrence Rapp from the State Attorney's Office. I'm in courtroom 3B with Judge Nicola. You guys have a client here ready to plead. Trying to get hold of Carrie. I don't know if she's currently tied up. Yes. Last name is Prado. Case number is 20-886. And if Carrie isn't available, if someone can run down for him just to accept the plea, yeah, I think the plea form. Thank you. I'm going to try and get a hold of Carrie and send someone down.
Okay, that sounds good.
Do I have to wait for a lawyer or can I ask questions about the please?
Well, because you're represented by an attorney, we do have to wait for the attorney. We do need to have it.
Will I be able to have contact with the kids?
That's something you'll have to discuss with your attorney. I don't know whether there was any proposed limitations, but why don't we do this? As soon as the attorney gets in, we'll put in what the offer is on the record. It may or may not include something about the kids.
And another for the 6 battery, which I'm already doing a program of that. I'm already in the court session.
That's another thing that we need to probably have the attorney here when you ask the question. I'm happy to answer your questions because I think they're very easy to answer. But because you have an attorney, we have to have the attorney here before I can address them. We'll either have her here in a minute or we'll have somebody else from the public defender's office. I realize I set this kind of last minute and we've been setting a lot of stuff like that lately. So it may have just kind of fallen off the radar. But we'll get you taken care of this morning, sir. I don't remember. Let me look at your first appearance order. Oh, let's see here.
I'm going to clarify the questions with Mr. Stewart as well.
That would be great. Mr. Rabb, my first appearance order was during the pendency of the action that there was coordination of contact through CAC. So we definitely need to clarify what the state is looking for with respect to the lady that was involved here and the minors. Good morning. I realized that when you left that you said I'll see you this afternoon, and I neglected to say, wait a minute, we have a plea that's set at 11.
I knew that we did. I was just actually continuing to work for this afternoon with our kid, and I lost track of time. I apologize.
No, that's no problem. I know that your client had some questions about the plea and about some of the things that he's been doing and with respect to his kids. If you want to take a minute and talk to him and talk with Mr. Rabb just to see if that can be figured out, please feel free. Personal information on count 2. All right. All right, we're going to go off the record for a minute until we get everything figured out. When I look at the DP case, it appears that it's in judicial review status, which means the case is progressing forward. And your client, before you walked in, had a question about the kids. It seems to me that it would make sense to have the contact go as it's being directed through the juvenile dependency case.
Yes, Your Honor. In that case, it's going to close in March, which was where my client's level of concern came. Because as of now, out of this case, he's not allowed to have any sort of contact unless it's through the DCF case.
It's through that. Actually, my initial order said through CAC, which it would make more sense to go through the DP case. But then these parties are married, and I don't see an action for divorce that's being filed. So the divorce court is really the one that should be determining contact and communication, especially if a DP case is closed. But what do you guys suggest as far as a resolution on that? Because I don't want there to be a lapse so that this gentleman doesn't get to see his kids.
Yes, Your Honor. And just to clarify.
Sure, of course.
Absolutely.
Your Honor, just to clarify, I am still showing that there are 2 charges pending. It is a violation of injunction and a battery. It's going to be the same plea for both counts, and they will run.
Let me just go back, because I thought I saw a notice of null pros on one of them. Let's see here. So it says 7/15 information filed, and then also 7/15 notice of no information on count 2. Actually, that's weird. Okay. Well, actually, it says notice of not filing charge, battery, touch or strike, first degree misdemeanor, which would have been the second count here, and also obstructing or tampering. So it's just a little confusing about how it was done. Then there's an information. It says information filed on both counts. So is what you're saying, Mr. Rabb, is that the misdemeanor information supersedes that notice of no information that was filed? It's just so weird because they were kind of filed at the same time. I just want to make sure I know what we were going forward on.
That's my understanding.
Okay. And is that your understanding, Ms. Armpriester? And yours too, Mr. Prado? Okay. Well, as long as we're all on the same page, I just want to make sure that we weren't going forward on something that had actually been removed from the case. So,
Yes, Your Honor.
all right, we need to get you sworn in, sir.
Raise your right hand.
You solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth.
And Your Honor, to answer your question regarding resolution.
Yes, thank you.
Yes, Your Honor. The state's plea offer, and this has been confirmed with Mr. Stewart, state's plea offer is an adjudication of guilt for cost of prosecution, $398, and cost of investigation, CCSO, 12-month probation, batter's intervention program, a no contact order with just the victim, except that contact may be made over the phone, text, or email, and that communication shall be limited to their shared children. There is no restriction on communication with the children.
Okay.
And that those are the same terms for both counts, and those are going to be correct.
Okay.
We would also be seeking public defender fees, Your Honor.
I figured.
Thank you. I still have to ask.
I think it's also statutorily required. I learned that when I became a brand new judge, and I had a hearing where I had not imposed the cost of prosecution. And there's actually a statute that allows the court not to impose the cost of prosecution if they're not requested, strangely, but you cannot waive public defender fees. So I guess that's something, I don't understand the law. Ask Judge Crown for it, because he's the one who came in with the statute and put it on my desk. And I was like, it's one of those where you think, oh my goodness, I think I might actually be in trouble for this because I'm getting a meeting on it. And then I found out that I was actually okay with it. But then if I were to say, no, I'm not going to impose the public defender fees, that I would have been wrong. So definitely was a little bit of controversy early on in my brand new career that I wished to avoid.
The defense bar has better law.
But it was actually the one and only time that I think I had a state attorney who didn't ask for the fees. So that was the, usually you guys always ask for it. So that was just an unusual circumstance that we don't see very often. So, Mr. Prado, this is what you want to do today to resolve your case, sir? All righty. Yes, you may. And let's get you sworn in. Oh, he is? I'll tell you what, I'm losing brain cells by the day being in this courtroom. Sorry about. I know, right? It's a lack of oxygen flow. Well, I could go on all day long, right? But we just won't.
That I'm holding current status report from Collier County Counseling, that my client has been engaged with substance abuse counseling, he's making good progress, and that he's also been referred to domestic violence classes his bit, and that he's also making good progress on that.
Right.
He has completed 4 sessions of the domestic violence bit, and his caseworker is also aware of this, and his provider, Mr. Kruzowski, who completed these states that he's making good progress all around.
Okay, that's wonderful. I'm glad to hear that, sir. All right, so I need to have you first state your full name and your date of birth for the record. And Mr. Prado, you've been charged with violating an injunction for protection against domestic violence and with battery, both of which are first-degree misdemeanors, which would be punishable by up to 364 days in the Collier County Jail per count. Do you understand that? And to the charges, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? Do you understand all the rights that you'll be giving up by entering into this plea? Are you entering into this plea because you believe it's in your own best interest? Has anybody threatened you or made you any promises to enter into this plea? Are you currently under the influence of any drugs, alcohol, or medications that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you understand that if you're not a United States citizen, this plea would likely be used against you in a deportation proceeding? And you've been represented by Ms. Armpriester. Are you satisfied with her advice? Do you have any questions of either her or the court before the court accepts your plea? Do you have any other questions for the court? And sir, do you understand that both violating an injunction for protection against domestic violence and battery are enhanceable crimes, which means there are circumstances in which the crimes could be charged as felonies? Mr. Rapp? Thank you. All right, Ms. Armpriester, you stipulate to a factual basis and venue for the purpose of the plea? And sir, I have reviewed the booking information in your court file, and I do find that there is a factual basis for your plea and that venue is in Collier County. I will accept your plea, find that it's freely, voluntarily, and intelligently made to the charge of violating an injunction for protection against domestic violence and the charge of battery. The court will adjudicate you guilty on both counts, and it will be 12 months of supervised probation. During that time, you will attend and complete the batterer's intervention program. You will also have no contact with the victim except as may be made to communicate regarding the kids, regarding by phone, text message, or email. There will be no restriction with your communication or your ability to see your kids, except as you have through your current Department of Children and Families case. They will dictate that, sir. Both counts will be concurrent. There will also be court costs, the cost of prosecution, and all applicable public defender fees. $398 is payable to the Collier County Sheriff's Department as cost of investigation. Sure, and I'll give you 90 days to pay. I will tell you, sir, do everything you can, especially with respect to the communication, to keep a record for yourself, because any little thing that says anything else other than wanting to see the kids, how are they doing, or anything like that could be a violation of this order. So we don't want you to violate, and you've got, at least the one appears to be a teenager, which makes it an interesting dynamic as it is. And right now you've got this other difficulty with the mother of your children. So do your best, please, to just make sure that you only limit that contact to communicating with respect to your children. And I hope this is the end of it for you and that you guys can figure out a way to parent these kids as separate individuals. It's very, very difficult. I'm sure it is. So good luck to you with this. I'm glad we were able to resolve it for you today. Thank you. Yeah. Oh, yeah. I mean, we've been doing this for months now, and I still always forget about the button thing. Yeah, it just happens.
Your Honor, we excuse.
Yes, sir. Thank you.
Thank you. We'll see you tomorrow.
All right, sounds good. See you tomorrow. Oh, and I did send you guys spreadsheets. Did you guys get them?
Yes, ma'am.
So my idea behind doing that was just so you guys would see what I'm showing as the oldest cases. I don't know yet, like, who's in custody and what we're going to need to do with that, but I kind of did that for my own kind of mental preparedness with 2 days of having pre-trials. And I thought, since I spreadsheeted them, I'd just share them with you guys. Sometimes a spreadsheet makes it easier to figure out. I don't know. That's how I look at it.
I told Ms. McAllister to send my appreciation to you.
Okay. Well, you will find that I spreadsheet everything. I don't know what it is. It's just, I happen to be just one of those Excel spreadsheet kind of brain people. So whenever I do those, I'm happy to share them.
And Ms. Humphries and I have been discussing cases that could either easily resolve or that may be in custody.
That we can try. Okay, sounds good.
One more thing, Your Honor.
Oh, yes.
Did you want me to put in there, sorry, you wanted to report to probation immediately, or?
Oh, and he just left. We should tell him to report to probation like now. Oh, there he is. Hello. I thought you left with this arm priester. Yeah. So if you can go downstairs to the first floor, then they can get you signed up for probation. Okay.
You want me to put that in the judgment as well?
You can leave it. He's going to go right now. I believe him.
Just wanted to make sure.
Yep.
He was just waiting for the judgment.
Yep. Sounds good. All right.